It's my pleasure to welcome you to today's webinar. For the past years, Pastime has actively supported the industry through its work in compliance initiatives and advocacy, including ongoing engagement with key regulatory and legislative issues impacting dealers. Pastime has maintained a strong relationship with the FTC over the years, so we're particularly interested in the insight that'll be shared today in today's discussion. We're proud to be the sponsor of this three-part series, beginning with an important look at recent warning letters issued to auto dealers and ongoing responsibility to protect consumer information. So thank you for allowing Pastime to be a part of this discussion today, and let's begin.
Good afternoon, ladies and gentlemen. Thank you for joining part one of a three-part series of NIADA's webinars. Today's was originally styled as a safeguards rule webinar, but in light of the FTC's March 13th warning letters to 97 dealerships regarding advertising transparency and potential violations of Section 5 of the FTC Act, we decided to split this up and start things off with a quick discussion from the FTC to provide a brief overview of the warning letters and advertising transparency, and to answer a few questions that we have prepared in advance based on some feedback that we have received from our members. So allow me to introduce Chris Maffarge. He's the director of the Federal Trade Commission's Bureau of Consumer Protection. He's an experienced consumer protection lawyer. He served in the first Trump administration as a senior advisor to both the director and the deputy director of the CFPB, advising on enforcement, rulemaking, supervisory exams related to the country's largest banks and non-bank financial institutions. Prior to assuming his current role, Director Maffarge was then FTC Commissioner Melissa Holyoke's chief of staff and attorney advisor. He also worked in private law firms as an in-house lawyer. I think it's important to note another noteworthy element of his professional experience, which I recently learned, is his time working in his family's auto dealership. So Director Maffarge brings a practical understanding of how car dealerships operate to his work at the FTC. Director Maffarge, the floor is yours with our gratitude.
Thanks, Patrick, and thanks to NIADA for having me here today. It's a real privilege to be here to get to speak to all of you. I'm the Bureau Director of the Bureau of Consumer Protection at the FTC, and I guide all of the FTC's enforcement efforts under the consumer protection laws. One issue that is central to our positive agenda here at the agency and for the administration more broadly is pricing transparency. And I know some of you have seen these efforts reflected in our recent warning letters to 97 dealers. In response to the letters, I understand that folks have a number of questions, and I want folks to understand those questions are very important to me, and they're very important to the chairman, which is why I'm here today. In addition to engaging with you all in this webinar, we intend to issue FAQs in the coming months that are going to answer some of the more nuanced questions that we've been receiving on these particular issues. So I'm hopeful that this engagement will hopefully provide some guidance and improve folks' understanding about what it is that we're trying to accomplish with this initiative. And with that, Patrick, I'll turn it back over to you.
Thank you, sir. I do have a few questions, and let me just start off by saying I think I speak on behalf of everybody who's on this call, how grateful we are here that there will be clarifying FAQs on such an important matter. So thank you in advance to you and your staff for agreeing to do that. That, in fact, was one of the topics I wanted to address. But let me start off by just noting that we've received a lot of positive feedback regarding these letters. Our members embrace this type of market conduct policing. We believe that, frankly, the market works best when you have a level and competitive playing field, and this type of policing of market conduct is exactly how we get there. But one question that we have received from a number of dealers, Director Maffarge, is, does the FTC have some sort of a formal process through which, if a dealer were to see some market misconduct within their community and their industry, is there an avenue through which that can be shared with the FTC for a potential follow-up?
Sure. Yeah. So there are multiple avenues. Obviously, they can work with NIADA to get those complaints to us. You can reach out directly to our staff. You can also report problems on reportfraud.ftc.gov.
Fantastic. Thank you very much. And we appreciate allowing NIADA to play a conduit role as appropriate in that particular fashion. Another question that we've received is it's regarding federal versus state laws. And we're curious if there's conflict between a discrete law at New Jersey, if you will, regarding a particular fee that under the state law may not need to be disclosed as the out-the-door price. If you could just clarify to the best of your ability, in those particular instances, is it the FTC's view that those state laws are preempted?
Sure. So I think first it's important to emphasize that I don't believe that there are really many instances of any conflict between federal and state law. I think for the most I've seen there are perhaps some nuanced examples or fact patterns that may present some tension. But to answer your question directly, if federal law conflicts with state law, then federal law wins. And in this instance, the expectation under federal law is that the total price that's advertised reflects all mandatory fees that a consumer will have to pay in order to purchase the vehicle.
Understood. Thank you for that clarification. That's important to everybody on the call. Let me just switch to advertising transparency, which of course is the crux of the issue. If a dealer is using a third-party platform, and I won't name any, there's plenty out there, but if they are using one of those, who is responsible for ensuring that the price reflected on that particular platform is accurate, specifically in cases where the platform is at fault for the advertising error, whether it's a fat fingering issue or a failure to update the platform, any other scenario that is really on their end rather than the dealer?
Sure. So, at bottom, the crucial question is, who's in control of the material that's presented to the consumer. So if it's the case that the dealer is the one that's inputting the information and inputs information that's incorrect or misleading, obviously it's the dealer that's liable. If it's the third party platform that interposes or does something that to contribute to or to create the misleading impression, then it would be the third party platform.
Understood. Thank you for that clarification. Along those lines, for recently sold vehicles, does the FTC recognize any sort of a grace period between the sales date and the point at which the vehicle is no longer advertised as available before the dealership is considered to be out of compliance? In other words, if there's a lull period between a car rolling off the lot to a buyer and that car being removed from whether it's the dealer's website or a third-party platform's website, if there's some type of a grace period that you recognize, I think it would be important for us to know.
Yeah, I mean, I like from my perspective, my own experience here, my own experience was that if a car was sold, we would take the car down off of the website, quickly. And I think the idea there is that, I mean, I don't really see a scenario where if you sell a car on a Monday, there it really should be the case by either that day or the next day, the car should come down.
Okay, I appreciate that. And that kind of gets to the question earlier about control and using the third parties. And if a dealer takes the appropriate steps and measures to contact TrueCars or whatever the case may be to say this vehicle should no longer be advertised, the control mechanism, in your opinion, would fall with, since there's a paper trail going to that platform, the onus and the responsibility would lie at that point with the vendor rather than the dealer, since they've taken the appropriate steps to ensure communication with that particular platform that this car is no longer available and should no longer be advertised.
Yeah, I've never experienced advertising on that website. In my experience, the dealer's in complete control over what gets uploaded on the third-party website. So, I mean, obviously, all these things are fact specific, but in my experience, it's always the case that the dealer could just go on and take a listing off. But if there's a different set of facts out there with regard to a specific type of third party, obviously we would be we would look at those particular facts to understand who's in control.
Thank you. Yeah, and we're just being very conservative in terms of making sure that we're doing right by what's required under the law, hence my follow-up question. And then the last question I have for you, and it's one that certainly you've received over the past couple of weeks, it's regarding doc fees. And I know there's been a lot of intrigue about the application of doc fees when it comes to the total price. And it's our understanding that, of course, that only mandated fees may be excluded from the advertised price, the sales tax, title, registration. Does that mean that the FTC expects doc fees should be included in the advertised price? Because again, there is some confusion depending on who you ask.
Yeah, the question is unequivocally yes. It's a fee that dealers require consumers to pay. It should be reflected in the total price. And that principle governs regardless of the name of the fee that the dealer gives to it, whether it's a doc fee, a service fee, a paperwork fee. These are all these are fees that the dealer is not required to make the consumer pay, and that's the key.
Well, this has been great, sir. And I just want to reiterate our gratitude on behalf of NIADA's 13,000 members, how delighted we are to hear that you will be following up with some clarifying FAQs. I think those will be well received. And to the extent we can serve as a resource as appropriate, please feel free to reach out through your staff, and we'd be happy to provide anything that we can to make that a good source and reference. So thank you very much for joining us. It means a lot to us.
Yeah, thanks, Patrick, for having me. I really appreciate it.
Thank you.
Take care.
Take care. Thank you. Okay, ladies and gentlemen, thank you for your indulgence with that. We felt like it was important to repurpose part of this webinar just to have an audience with the person who signed those letters. I know there's been a lot of news reports about this. There's been a lot of contemporaneous clarification about who's responsible for what, and we just wanted to hear it directly from the authoritative source. I should note that nothing that you're hearing today should be construed as legal advice. If you do have questions that have legal equities, we would encourage you to talk to a legal or a compliance professional. If you need a reference, please reach out to me. I would be more than happy to find a capable attorney or a compliance professional that can meet your needs. So with that said, we're going to move on to the safeguards rule. So if I could have the deck projected. All right. Well, thank you very much. I want to once again thank our sponsors, Pastime. They are a great partner here. They will be sponsoring this and the next two, so I would encourage you to attend those as well. Next slide, please. Okay, so because this is a webinar regarding a compliance obligation, we want to be precise in terms of any responses to questions that you have. So I'd ask that you please use the chat function to submit your questions. We are going to provide responses in writing after the webinar, and we'll also include a sample safeguards checklist that you can use for your purposes of complying with the rule itself. So next slide, please. Okay, so what is the safeguards rule? I know that a lot of you probably know what the safeguards rule because you comply with it, but its legislative history is it started out as a provision in the Gramm-Leach-Bliley Act of 1999, which was, I would say, the most comprehensive financial modernization law in several decades. And whenever you do a comprehensive financial services modernization bill, you tend to have a lot of provisions in there that deal with things like privacy, and in this case, dealing with data security. So the safeguards rule actually implements Section 501 and 501(b)(2) of GLBA. GLBA passed in 1999. The rule itself was promulgated and finalized in 2003. It was amended again in 2021 and then in 2023 again to represent advancements in technology and just real world scenarios that required a little bit more updating and guidance to ensure that dealers and anybody else that was falling within the scope of this rule understood what their obligations were. Next slide, please. Okay, so in a nutshell, really it's a data security bill. So if you are a financial services provider under the purview of the FTC, you are required to comply with this. And it is about making sure that the information that you collect as either a financer or a leaser of vehicles is appropriately protected. And we'll get into the weeds shortly, but it requires businesses to implement IT security programs to ensure that that information that's being brought in is being properly protected. You have to design to ensure that you're doing everything in your possible power to prevent data breaches or to mitigate data breaches and identity theft, and just general misuse of customer information, both by pernicious actors that are penetrating your system and, of course, internal employees as well. So there's and we'll get into this in a while, but that really gets into the need to know. So next slide, please. Okay, so I mentioned this earlier, but why does it apply to dealers? You are a financial institution if you are arranging financing. Whether it's in-house as a buy here, pay here dealer, and I know that a lot of our participants today are buy here, pay here dealers, or if you arrange finance through third-party lenders, or if you're in the business of leasing vehicles. Essentially, if you are collecting and transmitting customer information that is tied to financial transactions for leasing or financing to lenders, you are required to comply with the safeguards rule. Now, just a couple of examples are listed below, but really covered information is personally identifiable information, the type of information that can be used to steal one's identity and use it for negative purposes. That includes social security numbers, dates of birth, information that is pulled from credit applications, trade lines from credit reports, income information, virtually anything that you're collecting in terms of that body of info that you need to make responsible credit decisions, that falls within the scope of the type of information that needs to be properly safeguarded as part of the rules compliance. So next slide, please. So this is a high-level overview, and again, we're going to get into the weeds in a while, but really the main tenets of the rule is you have to develop a written security program that sets forth how your dealership is complying with the rule. And let me just note by saying that if you are investigated by the FTC, one of the first document requests they are going to seek is your written security program. And we'll go into a little bit of what that should look like, but I just want to start off by noting just how important that particular provision of the rule is. You have to obviously protect the confidentiality of the information and the need to know availability of that information. You should be identifying the access risks. In other words, who's getting access to the information? Is it appropriate? Should they not? And then safeguards and controls to ensure that those particular accesses are they have the right guardrails on. And the most importantly, there needs to be regular testing and monitoring of those security measures to ensure that if any updates are needed, they're made in a timely manner to ensure that you don't have soft vulnerabilities. Next slide, please. Now we're going to do a deeper dive here into some of the specific obligations, really just extrapolating on some of the points that I made a moment ago. So if I could get the next slide, please. Okay, so first and foremost, somebody at your dealer needs to be designated as a qualified individual. The individual can be an employee, it can be an affiliate, it can be a service provider, but most importantly, that individual needs to have the expertise necessary to manage security systems. Important to note, though, there are no specific certifications that are required. It's an informed judgment call based on a person's ability to discharge those responsibilities in a responsible manner. And that includes overseeing and implementing and enforcing the plan, managing the risk assessments, monitoring the safeguards to ensure that everything continues to be appropriate and no changes are needed. And then, of course, reporting annually to senior management or ownership, depending on the size and the scale of your dealership, on the status of your plan. Next slide, please. A written risk assessment, which I noted earlier. This is critical. This is something that, again, the FTC will want to see. They'll want to make sure that you have set forth precisely how you are going to assess your vulnerabilities based on the size and the scope of your dealership, and that assessment is reflected accordingly based on your footprint. It has to evaluate both your internal and external threats. Yes, internal employees can be a threat as well. Access to sensitive information. If you have teenagers from the local high school who are detailing your vehicles, they certainly have no need to know and no need to have access to that information. Your system vulnerabilities, like how often have you updated the software and your malware to software to keep those threats from penetrating your system. And then ongoing effectiveness of your existing safeguards to ensure that you're keeping up with technology. It has to be updated periodically, particularly in situations if your dealership has experienced changes, whether it's in ownerships, or if you've identified some threats or you've had past attempts to penetrate your system. That's a good time to do a hot wash on your written risk assessment and make any appropriate changes to ensure that whatever those threats are have been captured by the updated version. So next slide, please. Access controls must be implemented. You have to limit access to to information that are need to know. I gave an example earlier about detailers having access to this information. It really is role-based. Obviously, your F&I shop should have access to this information, but your detailers should not. You should have unique user credentials. Everyone shouldn't be using the same username and password. Passwords need to be secure and appropriately driven, whether it's through alphanumeric and special characters, the same types of things that we use to lock down our own personal systems at home. They should have the same types of systems locking down your systems at your dealership as well. And most importantly, if you offboard employees, immediately terminate access so they can no longer access this information. Next slide, please. Okay, so this one is a little tricky. I should note, there is no one size fits all when it comes to complying with the safeguards rule. That the FTC recognizes that. So while you are required to encrypt customer information, encryption, if it's determined not to be feasible, if you're a small 3-person shop, you just need to make sure that you document what those compensating safeguards are. And those can be strict access controls, multi-factor authentication, a comprehensive risk assessment, regular penetration testing, and vulnerability scans through software providers, and just active detailed logging to detect any unauthorized access. But that really applies when you're transmitting that data over your external networks from your dealership onto those third parties. And also, of course, if you're storing that information, you need to do so in a very safe and locked down encrypted device or server to ensure that anybody is accessing is going through the appropriate login protocols to make sure that they are entering the appropriate credentials that have been issued to them as an authorized official. Next slide, please. Okay, multi-factor authentication. I think a lot of us are familiar with this in our normal lives, but it applies to the Safeguards Act as well. MFA must be implemented for individuals accessing the systems. That includes that PII. Just a few examples that I put out here for your review. One that we're probably most comfortable with in our daily lives is password and mobile authentication. That, of course, as you enter your password, you get the immediate prompt that says, what cell phone number should we send a 6-digit code? You click which number that you've included, you get that code on your cell phone, you enter it, and then you're in. And then some people still use RSI tokens. That's a little key fob that provides a randomized 6-digit code that you can use in lieu of a mobile authentication. And then some folks prefer to use the password and the biometric verification. That, of course, is facial scans, retina scans, thumb scans, just something that's individualized based on that particular person that's beyond just the password. Next slide, please. Monitoring and testing. This is also critical. You've got to do it regularly. You need to monitor to make sure that those test security controls are appropriate and up to date. Such examples include, regular penetration testing, and there are no shortage of third-party vendors that will provide penetration on your behalf. For those of you who may not know what that means, it's essentially a white hat hacker that goes in and attempts to get into your system. And if they're successful in doing so, they provide you a report telling you where the soft vulnerabilities are and ways to mitigate what those soft parts are to ensure that your network is appropriately hardened. And part of that is continuous systems monitoring to make sure that if you do penetration testing, you've put those guardrails up to provide as few avenues for entry as possible. And then regular vulnerability assessments. Again, dealerships change, they evolve, whether it's through ownership, you may increase your footprint through a couple of rooftops. That's going to change the amount of information that you're bringing in. That should also change the way in which you are viewing yourself as vulnerable and making appropriate changes to your program. Next slide, please. Okay, training and awareness. This is also important, and it's going to be something that the FTC is going to ask you about. They want to make sure just because you have a manual in place that you are also ensuring that your employees are aware of their responsibilities pursuant to that manual. So you must train your employees. It has to happen at least annually. I recommend doing it more than annually, but at least annual to be in compliance with the rule. And it should cover things like phishing attempts. I think everybody knows what that is. You get an email where instead of an L, it's a capital I. So you think it's coming from a legitimate source, but in fact, it's somebody that's attempting to fool you into clicking on something when it is in fact a way to try and find a backdoor into your system. Making sure that people are handling the information properly. They're not using their cell phones to take pictures of people's driver's licenses and using that as a storage facility. We talked earlier about passwords and device securities, just reiterating that you want to make sure that you're using sophisticated forms to ensure that it's not just password 123 and everybody's using it. You're using alphanumeric special characters, 16 characters, and all of the other third factor to make sure that you are in fact doing everything you can to ensure that not only are the people with the need to know getting in there, but you're making it difficult for them to do so because they have to go through a number of steps in order to get into the area where all this information is stored. And then, of course, in the unlikely event that you do encounter an incident, you have appropriate reporting procedures in place, which I will cover in a moment. Next slide, please. Okay, so service provider oversight. I know a lot of folks on this call either use service providers, or we may even have some service providers on the call today. If you are using vendors, you need to take appropriate steps to ensure that those vendors are also in compliance with the safeguards rule. So appropriate due diligence when you're hiring the vendors, making sure that they have appropriate information security and IT security protocols in place, making sure that that contract reflects those provisions and they line up with what you're required to do under the safeguards rule. And then, of course, ongoing monitoring of vendor compliance. Vendors change hands, they change management, and you want to ensure that as those changes happen, a watering down of what they've agreed to as part of their contract with you remains the same, and it's meeting those minimum standards that you have in place. Next slide, please. Incident response plan. This is probably fresh on a lot of people's minds. There was a large third-party service provider that was subject to a pretty bad data breach over the winter. I give them an enormous amount of credit for the responsible way in which they managed it. But the onus really starts with the dealer that is subject of an incident. You need to make sure that you maintain an ironclad written incident response plan, and that plan should include, at a minimum, the steps that you take to respond to security incidents, the individual roles and responsibilities, because remember, time is of the essence when it comes to an incident. You're dealing with people who are largely overseas, and the information does not sit on one server. It typically goes to another server in Honduras and another one in Costa Rica, and then another down in Africa. So the time is of the essence of moving quickly. And then, of course, once you've identified the source of the penetration, what you're doing to contain it and remediate it to ensure that the damage is limited. And then, of course, documenting and investigation procedures to ensure that you're following through to find out what happened. You're making sure that you have it all documented so that if you are investigated, you can show exactly what you did in the immediate aftermath to mitigate the problem. I would also note that when it comes to this plan, I don't think, while this is the minimum that you need, because the safeguard rule does allow flexibility due to the sophistication, you should really consider, based on the size and the scale of your dealership, If you have other procedures in mind, do not feel as though this is limiting. These are just the basics. I want to encourage you to add more to your response plan if you believe that you have other choke points that are helpful in terms of making sure that you're able to act as quickly and as responsibly in the immediate aftermath of any type of an incident. Next slide, please. Okay, you do, under the rule, have a breach notification requirement. If the breach affects 500 or more consumers, you have a requirement to notify the FTC within 30 days. You have to provide details about the breach. I'm happy to follow up on what those details look like as part of the question and answers that we will disseminate. And then you submit that information through the FTC's reporting system. Now, I think it's also important to note, based on that data breach that I referenced earlier, that as part of that, there are, I think, no less than 32 states that have similar reporting requirements as well. So if you are subject to a breach, please make sure you check whether it's with your state attorney general or whatever competent authority oversees your dealership at the state level, whether or not they have similar reporting requirements, and follow through accordingly. That is important. I think it's also good business practice to report any incident to the FBI's Internet Criminal Complaint Center, commonly known as IC3. They do a very good job following up on these things. They're able to follow these types of fact patterns that they see, and are actually quite good at containing these problems a lot quicker than people would expect. So I just give that to you as food for thought. It's not required as part of the breach notification, but it's a good business practice to consider, and it's a very user-friendly process. Next slide, please. Okay, you are responsible to provide an annual report to either ownership or, depending on your size, your board of directors. And this is coming from your qualified individual that we spoke about earlier. And you have to provide a written report annually. Now, the minimum information that must be included in this report is the overall security program status, the assessment of those findings that's taken place as part of that qualified individual, the testing results, both the good and the bad, any security incidents that have transpired over the course of the year. And then the qualified individual should also provide, if there are any recommendations for improving the security plan. And while we're dealing with evolving technology, there's usually going to be some type of an improvement that can be made, particularly if your dealership has been subject to an attempt to penetrate your systems. That's the type of information that should be included in the report, and frankly, a recommendation for how to improve based on what that penetration looked like. If you are investigated, this is going to be one of the first things that they ask for. So, I said that earlier, but this is important, and this is really about making sure that you're not just creating something and putting on a shelf and forgetting about it. There's going to be about 3 or 4 things that the FTC will ask for immediately, and your annual report certainly is going to be one of those. So I would just stress the importance of how important it is not only to do this, but to ensure that whoever you designate as your qualified individual has the appropriate agency to conduct this information in a responsible and comprehensive way, because you want that report to be buttoned down, and you want to ensure that that individual is giving you this information, whether it costs money or not to implement, knowing that they're doing it with your dealership's best interest in mind. Next slide, please. Okay, so now I'm just going to go over some of the typical gaps that we see and some of the consequences that you're likely to face should you be found out of compliance with the safeguards rule, starting, of course, with the compliance gaps. Some of these are pretty obvious, but I think they bear just repeating. If you don't have the information security plan that I've talked about throughout the course of this discussion, again, that's the first thing they're going to ask for. If all of your employees are sharing the same login credentials, that's a huge no-no. I think that goes without saying, but that's the type of breakdown that's not going to be looked at favorably. If you are using vendors, you aren't doing that appropriate due diligence and regular monitoring to ensure that your vendors are complying with the safeguards and the appropriate choke points in place and the appropriate IT security protocols that match up with the type of work that you've commissioned them to do for your dealership. And then, of course, just poor annual employee cybersecurity training. That is a good hygienic exercise, regardless of whether the the safeguards rule applies or not, just making sure that we're all vulnerable to cyber actors out there trying to penetrate systems. So it's just a matter of best practice. It's always good to ensure that you're doing regular cybersecurity training, but more so when it comes to complying with the safeguards rule, because it is a tenet of a type of compliance gap that's going to be identified through an investigation. Next slide, please. Okay, the parade of horribles that I mentioned. These are the types of consequences that you'll see if you're found to be not in compliance with the safeguards rule. These are just some, but they're the big ones. Enforcement actions, civil penalties, mandatory compliance training on a remedial basis to clean up some of the issues that have been identified to be subpar. And then, of course, the reputational damage that your dealership will suffer from. We should avoid that at all costs, because those are going to reside on the internet, whether it's through Yelp or Google reviews. And once they're out there, they're very difficult to erase. So that's something that should be front of mind as well while you're thinking about making sure that everything in your compliance program is above board. And just general breach liability. If you have a soft target, if your system is a soft target, the last thing you want is to be known in the dark web as a soft target. So just making sure that you're constantly reviewing your processes, your protocols, all the choke points that you've built in to mitigate those liabilities best as possible, and listening to your qualified individual, the recommendations that he or she makes as part of that annual report, and giving them the authority to make those changes. It's a smart and wise investment in your dealership, not just to ensure that you're complying with this consequential rule, but also, again, to make sure you're being a good steward of customers' proprietary information. Next slide, please. That is the end. I didn't think I'd be able to get it through in the time that we did. I'm glad that I was able to. I want to reiterate just a few things. This is not legal advice. If you do have questions, please make sure you consult a legal professional, or if you need a legal professional, reach out to me. I'm happy to find somebody that meets your needs and your budget. And again, if you have not put your questions into the chat, please do so. I want to make sure that we give everybody responses to all of the questions that are asked. But I want to make sure, because these have supervisory consequences, that we're being very accurate and very precise. That's why, while I'm certain I could answer your questions here live, I want to make sure that you actually have something that you can refer to at a later date with information that is meaningful and useful. And as I noted, I'll also provide a sample safeguard checks list. And then one last thing that I want to note, some of our state affiliates, Texas and Florida and Alabama come to mind. They have really good safeguard compliance training available. So if you are a member of that state and are interested in going through a training program, please reach out to your state association. I just named 3 off the top of my head. Certainly there are more. I would encourage you to look at that. It's always good to take those refresher courses. Again, this is an important rule. The FTC put out FAQs just in June of last year. NIADA's position is that is a good sign that this is going to continue to be a priority matter for the FTC. So just allow me to end by stressing that it is critical to make sure that everything that's said today is taken very seriously. If you have additional questions, next slide, please. This is my email. Feel free to reach out to me. I will do my best to get a response to you as quickly as possible. I will certainly prioritize it, but I want you to know that we at NIADA are a resource. We want to make sure that you're set up for success. And if you have questions and we're able to answer them, we're giving you those answers as quickly as possible. So that concludes today's webinar. If you are interested, we have 2 more. Next Tuesday, the 28th, we will be doing a webinar on the Fair Credit Reporting Act and its implementing Regulation V. And then on the 5th of May, we will be doing a webinar on the Equal Credit Opportunity Act and its implementing Regulation B. I would encourage you to attend those as well. This particular webinar and the 2 that will follow are being recorded and archived. So we will make sure that in addition to responses to your questions, we're also making these webinars available. So if you wish to share it with your staff or review it yourself, So with that said, I want to thank you all very much for attending. This was great. It's always wonderful to see people logging on to a webinar dealing with compliance. It's exactly the type of information that we like to see given the premium that we place on compliance. And I look forward to seeing many of you in a week's time when we go over FCRA. So with that said, thank you again to Pastime. Thank you to my NIADA colleagues for facilitating this webinar, and I look forward to seeing you all next week. Have a wonderful rest of your day and the rest of your week. Thanks for joining.